Thank you, worthy director, sir. And thank you, Miss Sirisha, for such beautiful words for me. I had myself forget that these all achievements had been credited to me by the institutions. So it is my pleasure to be in the part of your journey for the trainings. And as I think the training is the only important tool which can enhance and sharpen our professional ethics so that we can we can fight for the people in the court of law. Now, let me start with my presentation. Now, is my presentation visible?
Yes,
No,
sir.
Tell
sir.
me, is my presentation visible?
Visible, sir.
Yes, sir.
Visible.
Yes, sir. Visible, sir.
Visible, sir.
Okay. So, Jai Hind to all of you, dear friends. My topic is strategic approaches to witnesses, examination, and cross examination, a prosecutor's guide to effective advocacy. If there is any problem in the presentation, please do tell me. My slide is moving.
Slide
Is
not
my slide
visible, sir.
moving?
No,
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 sir.
no, sir.
Slide is
No, sir.
not visible,
Slide
sir.
is not
Slide.
moving.
No slide, sir.
Now, slide is moving.
Slide is not
No,
visible.
sir.
Slide not visible,
No,
sir.
sir. Presentation slides are not visible, sir. Only we can see.
There is no slide, sir.
Now,
No, sir.
now,
Yes, sir.
Yes, yes,
Visible.
sir. Yes, sir.
Yes,
Visible.
sir.
Yes, visible, sir.
Now, okay, sir.
Okay.
now what? Before starting my today's day for the lecture, what I feel that an organization which does not adapt becomes irrelevant because this line means that life is a continuous process of learning. If you will not learn, you will become irrelevant. This is for the institutions also. And institution is because of us. If we are always learning, the institution does not become. We also do not become relevant. Now, in my opinion, you may differ the opinion also. What I feel prosecutor is just like this image, which is visible to you all in my on my PPT. The man holding the bow. Is the video picture in visible?
Visible, sir.
Yes, sir. Visible, sir.
Yeah. Now, this is my imagination that how a prosecution works. The man holding the bow is portrays the investigating agency. You can see how smartly the person holding the bow is standing. This depicts, portrays the investigating agencies having many institutes for training them, such as the premier institutes for the IPS Academy Hyderabad, and many other police academies in respective states. They are sharpening their edges. Many other institutes for paramilitary forces, they are sharpening their edges. But, and the boy's appearance, now the appearance can be of the prosecutor, appearance can be of the system, how they are giving us. Now the arrow is the prosecution. and the tip on the arrow is the evidence collected by the investigating agency. Now, what I mean that if arrow is very straight, very proper, then only that prosecutor can go and hit the board of justice, and the hit tip will be the arrow. The tip is the evidence collected by the investigating agency. If the arrow is not proper, how far the good evidence has been collected cannot hit the court of law, cannot go enter into the court of law, cannot present your case into the court of law. So, the how to make the arrow very clean and sharp? It can only be by the training. There must be a proper training, proper academies to teach the prosecutors so that they can also be a clean and very sharp in the court of law. What I feel, three qualities must be present in the prosecutor. First, he should be graceful, he should be respectful, and he should be intelligent. Now, graceful by your appearance, turn out in the court, office, and in public. You might be seen, I have seen many our brother prosecutors not coming into the court in proper dress, wearing jeans. This is not the proper way. When you are appearing in the court, your turnout should be very best. Your turnout in the public, your turnout in the public offices, that matters. Respect. You should be respectful to everyone. You should be respectful to the court. You should be respectful to the public. You should be respectful to the witnesses, because witness is our guest. Though the witness may be hostile, but we should be respectful. Because if you are respectful, you can extract many things which can. I can remember one case in my life. A witness appeared in the court of law, and the case was of accident case. Many people had died in that accident, and one of the passengers appeared in the court of law, and I knew that he was hostile because he was accompanying the accused. But the witness was old, about 60 to 70 years gentleman. And when he entered the witness box, I just gave him regard. I said, Namaskar, how are you? Would you like to drink water? Sorry for the delay, because there are many cases, so you might be waiting. And he was very much impressed. And after that, I said to him, please tell whatever you will take the oath, whatever you will say, we will speak truth. As then the witness was in the face. He said, that gentleman, I will not speak lie at this age. And the witness stated the entire fact in that case. If today I remember, if I would not have been respectful to that witness, then in that case, the hostile witness would have never deposed in actual facts. I never say in our favor or in favor of the accused. I only say witness stands there to depose what actually has happened. Because neither the defense counsel is on the spot. Only the witness is on the spot. So we should expect what he has seen, he should speak truthfully in the court of law. Now, if one is very graceful, very respectful, but he is not intelligent, then these two qualities will not bring fruits for you. You should be intelligent. Without being intelligent, you cannot plead your case smartly. So, you should learn every day. You should read every day. You should be well prepared when you are appearing in the court of law. Now, duty.
Voice is not visible, audible.
విష్ణుచంద్ గారు కట్ అయిపోయినట్టున్నారండి మీరు. విష్ణుచంద్ గారు కట్ అయిపోయినట్టున్నారు.
Good morning, sir. Good morning.
జాయిన్ అవుతున్నారంట. 1 minute, 1 second.
Looks there some certain problem is going on. It is automatically disconnecting me.
Okay, sir.
It's okay, sir.
Yes, sir. Now you are visible.
Slide are not visible.
Slide is visible.
Visible, sir.
Visible, sir.
These were not 7.
From where I was disconnected.
Intelligence, sir.
Sir, you are speaking about intelligence, sir.
Okay.
Respect the witness in the box.
Now I was saying that why truth always prevails, because it is flawless. And you should know the art of presenting the flawless truth. Because if we are not able to present the truth in the proper manner, then it will be shown in the court of law that they are not presenting the truth. And if once accused shows that we are not presenting the truth, the court will not believe us. Now, how to present that truth? There are proper tools how to present them. Now let us see. Working of attorney or prosecutor starts when he accepts the police file oblique brief for the scrutiny. And specifically in NDPS cases, when the first brief comes and APP, Assistant Public Prosecutors, appears in the application under section 52A of NDPS Act, he also accepts first time the brief when he appears in the court of law to oppose the bail also. So our work starts from that very day. Now, as per my experience, your experience might be different. It is reasons for failure of criminal case. Except, can anyone tell? But let us, actually this question is when we are physically taking the class. Now, except the reasons for hostile witnesses, what I think that mainly our cases fail. Mainly our cases fail because we are not having sincere toward the job. We do not own the file. Lack of knowledge, because of which lack of confidence, guidance to the police. Basically, friends, we being prosecutor, we are guide to the police. Police is expecting from us, and if they come and ask any queries, we should be in position to guide. Now, question is how to examine the witness and cross-examining them. Sixth, how to prove digital evidence, such as CCTV footages, video received on WhatsApp. Future of the crime is digital crime. So we should be very much clear how to prove digital evidence. And for that, what I say that there is no research and development by any of us. We are always busy in 9 to 5 to attending the courts, presenting the evidence, and our day ends. We do not do the research work why our case failed. We do not do our research work if there is any good case, how it can be made better. Now let us start with the topic how to prepare criminal and civil files. I am saying here civil files because in Himachal Pradesh, we are conducting civil cases of the government too. That is why this topic also covers the files for civil cases, but here I will not take that topic. Criminal cases is just like playing criminal cases, preparation of criminal cases. What I think, be a guide to police and own the file. Scrutiny of police file should be in the pro forma provided in the prosecution manual, preferably computerized. In Himachal Pradesh, Government of Himachal Pradesh, Directorate of Prosecution has provided scrutiny performance to examine the police files. The performer makes the prosecutor and it guides to how to examine the police file. So what I feel that preferably the examination should be done in the computer so that it is readable. Examination of police file is like playing chess. When you start playing chess, you know the tentative moves of your opponent. So you should keep those moves in your mind so that those moves can be properly tackled. Perusal of the complete police file. When you are examining the police file, it should be perused properly. During scrutiny, we should examine the file by keeping tentative defense of the accused in the mind. For example, in accident cases, what are the tentative defense? We all know because we all are working in the court of law every day from 9 to 5. And we know what are the tentative questions will be asked by such advocate, this advocate, A advocate, B advocate, C advocate. And generally they are of the same nature. So we should protect our cases, we should present our cases in that. Cases of 420, this is IPC. Your attack should be so sharp that accused should not have any defense. This, what I mean to say that when a case of 420 is registered against the accused and charge sheet is prepared, charge sheet is examined by the prosecutor, if it means a prima facie case is made. Now, in case of 420 always rests on the documentary evidence. It does not rest on the oral evidence. When the document is saying that the offense has been committed of 420 or 406 or 409, then how the accused can get acquitted? If the case was made out, we presented the case and accused is acquitted, then we should do research and development why the accused was acquitted. Because the case was not, it might be possible that case was not presently as per the law. Documents were not exhibited as per the law. Now, in cases of murder 302, 376 IPC. What will be the tentative defense of the accused? You should know. From the file it comes. What will be the tentative defense? Now, other cases of POSCO, SAST cases, we always, by the way of experience, we come to know that what will be the tentative defense of the accused. When you are examining the file, you should prepare the notes and note down important facts of the case. Before examining the witness in the court of law, conference with the witnesses is must. Now I know that in the courts of judicial magistrate first class, there are a number of cases. When I was posted as APP, at least 10 to 15 cases were fixed for the evidence. But you should prioritize the cases, which are important cases. Sometimes some cases are of petty nature. So priority must be fixed. You are not having number of cases for the 420 or 409. The priority should be for that cases. You are having very few cases of 326. Priority should be that. You are having very few cases of 304A IPC. Priority should be that. There are number of cases of only 279 and 337. So there you must fix the priority so that you can examine the witnesses which are to be prioritized. Selection of witnesses is very important issue. When you are doing the conference, you will come to know which witness is to be examined, which witness is to be given. I would like to explain one of my experience in one of cases. This is when I was posted as public prosecutor, deputy district attorney at Mandi. In one case, the defense, the case is of 306 IPC. It is the rare case that the husband has committed suicide and actually there was cruelty done on the part of the wife as per the police report. Now tentative defense, in this case complainant was father and elder sister was also staying with her father being divorced. She was divorced. Now I wanted, because father and daughter were of the same nature witnesses, father was complainant, so I wanted that father should be examined and I will give up the daughter being repetitive in nature. But during the cross-examination, one very important question was asked by the accused, that why accused wife of the deceased was not staying in her in-laws' house because your daughter is the is the reason why your daughter-in-law is not staying in your house. Now, this is a very important question asked by the accused to the PW1, to my complainant. Now here, if the prosecution does not examine the daughter who was staying with the father, it will amount to withdrawing the witness under section 114G of CR Evidence Act. So adverse inference can be drawn. So I was compelled to examine the daughter in the court of law, so that if any question is asked, such type of question that you compelled, your behavior is such that daughter-in-law is not able to stay in the house, in-law's house, then he should ask from her. And that answer will be properly given by that witness against whom specific question has been asked. So, gentlemen, selection of witness is very important in any type of cases. When you do conference with the witnesses, moral support, you support your witnesses morally also. Because moral support to the witness is very important. Witnesses are very much afraid in the court of law. Sometimes witnesses are appearing in the first time in their life. They don't know how to give answers. How the court, how to give evidence in examination in chief, how to respond to the cross-examination, professional process, cross-examination of the defense counsel. So, gentlemen, there should be proper conference with the witnesses, and you should only ask them to speak truth. Now, our duty is to garnish and present the truth before them. Gentlemen, here I would like to make it clear, garnish means crafting of evidence, but it does not mean creating of evidence. Sometimes, my brothers, I have seen that he has start creating the evidence. No, it is our not duty, because we are not in the crime scene. We were not in the crime scene, so we do not know actual truth. We are here to present the evidence available with us, that is evidence collected by the police before the court of law. So our duty is to garnish the truth and present it, not our duty to create that. You should know the difference between crafting and creating of it. Now, art of examination and chief examination. Examination. Now, in an examination, what I say, you should know what facts be presented in examination in chief. And what I feel that, gentlemen, whatever there is recorded in statement of a witness in under section 161 is comparatively easy. But when your witness becomes hostile, then you should know the art, how to bring out the truth from a hostile. Build faith of client. Your client, your witness, your complainant should have faith on you that you will fight for him. State is standing for him, because if you will build faith, he will respect you. He will have the faith on the system. He will have the faith on the chair. Now, when you will examine the entire file, entire evidence should be in the crevices of your body and mind. When I say body and mind, means that you should live your case. And living your case, especially in session trials. Before examining the witness, you should properly live your case. Your file should be properly in your brain and mind, body. You should think yourself how the witness will react in the normal situation. When some offense has been committed against his family, against him, sometimes he will behave abnormally. He will not behave like a computer, that any fact entered in that data, any data entered in the computer, that same data will be passed to another computer also. This is not human behavior. When any information is received by a witness that his brother or his family member has been killed, or any wrong has been committed against his family member, his state of mind, you cannot think of his state of mind, how he will react, because it is human behavior. And it depends upon man to man how that human behavior will act. When we do conference and start examining the witnesses, following things should be kept in the mind. First, witness must depose relevant fact, which will prove the ingredients of the offense. Narrate the scene of crime properly. Ordinarily, witness is not expected to do, expect, so he should not give opinion or what is his conclusion. Ordinary, now what I say, ordinary witness is not an expert. So he should not give opinion or what is his conclusion from the facts he has seen. I will explain this topic in further when I will take an example of a case. Next, many a time police has added irrelevant facts in the statement under section 161 CRPC. What I say relevant means sometime hearsay evidence, part of evidence is also and written in the statement under section 161 here. So they are irrelevant. Hearsay evidence is irrelevant because relevant evidence is direct evidence. And direct evidence is what I have seen, what I have felt, what my senses have seen, heard, or felt. Many a times, many a time in case of corruption, statement is too lengthy. It exceeds 4 pages or more. And I have noticed that relevant part is of only half or 1 page. So when you are doing conference with the witnesses, you should ask him what has happened. And if the ingredients of the offense are proved, crime scene is properly narrated, I think his evidence is complete. Any recoveries made in his presence, it should be presented in the normal behavior. He should not behave like a professional witness. We should present the witness in the raw manner, in the manner he is actually, but only which evidence should be garnished. Now, there is a disclaimer on my behalf that in my presentation, I have taken some pictures and statement of the witnesses. These cases, pictures and statements are only taken for learning, research and development so that we can learn from our mistakes and improvement can be done. Further, if any good is done, in that case, best would be done. This work of mine is not to defame anyone or to tarnish image of anyone. If because of my presentation, feelings of anyone is hurt, in that case, I feel sorry. So let us start. We must be very much clear when the witness is hostile. First thing, when the witness is hostile. For this, I will take example of number of cases. One of them is let us take the example of case under section 279, 337, and 304A of IPC. And the example which I am taking is of 304 AA. 304 AA is HP amendment in IPC, and 304 AA is an offense when any accident, because of any accident, death is caused or any injury which could cause death is caused. Under that circumstances, 3044A is slapped against the accused, and at that relevant time he was under intoxication. So gentlemen, for the case of accident, what are the ingredients we should prove? First thing, death or injury. Death is caused of human being or injury is caused to human. First is the ingredient. For 304 AA, accused was intoxicated at that time. Hello?
Okay,
Hello?
sir, you continue, sir, you continue.
Okay. Death or injury is caused by rash or negligent driving on the public way. This is the second ingredient, which must be proved by the prosecutor from the witness. And the third and the important ingredient is rash or negligent act is attributed to the accused. So when we are able to prove these all three ingredients in the case of accident, our case is proved. Now, what I feel that in a criminal case, evidence is just like different pearls. And we should know how to thread these pearls to make a one mala or a necklace. When you will be able to thread these all pearls, the necklace there will be a proper necklace. So you cannot say that one witness will prove everything. There will be a witness to the spot. There will be a witness for forensics. There will be witness for medical science. So there are many number of witnesses. And it is the duty of the prosecutor to thread these all pearls to make it a proper jewelry. Let us see what witness is deposing. Now this is a case in which PW2, Mr. M was a complainant of the spot. In his, he had seen the accident, and his statement was recorded under section 154 of CRPC by the investigating officer. Now, when he was examined in the court of law, he has deposed. You can see the witness, the statement made by the witness. He says that, submitted that at about 2 p.m., he saw a nano car of white color coming from Machial side. This is the place, name of the place, Machial side, and hit a lady named Meena and two children who were walking on the side of the road. This is very important. The victims were walking on the side of the road. This shows that they were acting in good faith as per section 52 of IPC. Negligent conduct cannot be attributed towards the victims. So clearly says he saw a nano car of white color coming from this side and hit a lady and two children who were walking on the side of the road. Now, it is expected that people will walk on the side of the road and vehicle will move on the road. Now, further what he says, thereafter the car, after hitting, left the road and hit with the safeda eucalyptus tree, which is near my house. I reached on the spot and saw the driver, the lady, and the children, and had sustained injuries who were rushed to the hospital. Now, he has clearly identified the victims, vehicle, and the manner of the accident. It occurred. Now, further, the accused was not able to stand on as he was appearing to have consumed alcohol. Drinking alcohol itself is a conduct of rationality, because good faith means is defined under section 52. Not acting in good faith is reversal to that definition. Now, drunken driving is not acting under a good faith. So, what he says, the accused was not able to stand as he was appearing to have consumed alcohol, and the driver disclosed his name as dash present in the court. Now, the witness proved all the three ingredients needed to prove a case of accident in which death has been caused. And to prove the section 304 AA applicable to Himachal Pradesh, he has also stated that witness was appearing to have consumed alcohol. Now further he says, police came on the spot and he gave the statement to the police exhibit PW2/A, and the police took in his possession the vehicle through memo exhibit PW1/A, and he put his signature on the memo. I have seen the photograph mark mark A1 to A5. Nano car in the picture is the same, and the pictures are of the place of accident. Now, in my opinion, this witness has deposed every ingredient, he has explained the entire scene of crime. Whatever I was saying, that what we expect from a witness, he should depose in the court. He has deposed everything. Now, last question. He said, I cannot say who was in fault in the accident. He's narrated entire story, conduct of the accused, conduct of the victims. No, I don't think he was needed to say because of whose fault accident has taken place. And only by saying this line, my brother has declared this witness hostile. And see, the cross-examination by the learned public prosecutor, it is incorrect that the alleged accident took place due to rash and negligent driving of accused, as he had consumed alcohol and caused the accident. Confronted with the statement mark 2/A, part 8A, where it is so recorded. Now, last question. It is incorrect that in connivance with the accused, I am falsely deposing before the court in favor of the accused. Now, question of mine with my dear friends sitting in this webinar, please, can anyone say this witness was never hostile? And when you are saying that I cannot say because of whose fault this accident has taken place, this amounts to giving opinion. Opinion can only be given by an expert under section 45 of Evidence Act. Sorry, I am saying Evidence Act, BNI. I am not saying Bharatiya Nyaya Sakshi Sanhita, because I am not presently posted in the district. I am posted in the higher education department, so I have not gone through properly. I have gone through, but I do not actually remember the sections, which are the new sections of section 45 of Evidence Act. What is the new section for 45 in the Bharatiya Nyaya Sakshi Sanhita? So I feel sorry for that. But I will speak on the IPC, CRPC, and Evidence Act. So this witness does not come under the category of expert. Witness, ordinary or normal witness is expected to depose what he has seen. What he has seen in the scene of crime. The witness has deposed in the court of law that what he has seen. He has seen the victims going by side the road, a car hitting the victims, driver of the vehicle was drunken. Now every ingredient was proved by the witness. I don't think the witness was hostile. And for the only thing that the witness did not give his opinion because of whose fault the accident has taken place, he was declared hostile. This is also what I feel. We should be very much clear when our witness is hostile. And after the cross-examination by the prosecution, last nail in the coffin is that it is incorrect to say that I am deposing falsely to support the witness. Gentlemen, where he was speaking the lie. He was speaking the truth. So friends, we should be very much aware when the witness is hostile and when the witness is not hostile. When the witness is hostile, what the questions are to be asked. Sometimes witness is speaking truth because he has noticed some limited evidence only. And the police has recorded the entire statement. And if it comes, if you are of the conclusion, the prosecutor is of the conclusion that the witness has spoken the truth, and the remaining facts which he says, or he was not at that moment when these facts has occurred, then if there is some other witness to that fact, and that fact can be proved through some other witness, some other documentary evidence, that it can be proved through that evidence also. Now, Gentlemen, I would like that any questions or queries can be asked in the mid of the session also, and we will take the last when I will finish my topic. That we will I will expect number of questions from you, because my dear friend brother prosecutors, I stand here to learn from you all also. I am a student of law for whole of my life, and I learn from everyone, irrespective of he is an advocate, he is a judge. I stand to learn from an ordinary person whose behavior I notice in the walk, while I am on the road, while I am in the house, while I am in any of the place where I am moving or traveling in. So let us see now. The actual photograph of the cross examination has also been shown to me, to you by me. Now, in this case, see, forensic evidence, the during when the accused was arrested, immediately, because he was also taken to the hospital, he was also injured, he was taken to the hospital immediately, and doctor has taken his blood and urine samples, and FSL has given the report. Now you can see in blood 89.93 mg percentage is the content of alcohol in his blood, and in urine 109.82 mg percentage is the present of alcohol in his urine. So gentlemen, so the driver was drunken is proved by the witness himself also. He has shown the behavior that he was looking that he was drunken. Now this fact has been corroborated by the documentary evidence, scientific evidence, by the forensics, that when they had examined the blood and urine of the accused, the such number of alcohol was present in his urine. So these two facts clearly prove that the accused was not behaving in good faith when he was driving the vehicle on public path. Now, ingredients are proved. Injury to human being is also proved. Your case is proved. Now let us come the next slide. Now let us see the PW3. This is a witness actually hostile. She says submitted that she is not aware about the date and month, but 2 years back she heard noise outside and and she was not feeling well. Later on came to know that the car hit Meena and two children, and thereafter struck the Safeda tree, and not aware about the number of the private vehicle. This witness was declared hostile. This witness is actually hostile, who is resigning from her entire statement recorded by the investigating officer during the investigation. So she is actually witness. She is hostile, but PW1 is not the hostile. Now let us see next. PW4, who submitted that he was on the way to his home on motorcycle. Is my PPT visible, friends? Please respond. Is my PPT visible?
Yes, sir.
Visible.
Yes, sir.
Visible, sir. Visible, sir.
PW4 who has submitted that he was on the way to his home on motorcycle, and when he reached where one nano car came from the Machial side in high speed, and he just crossed about 100 meters, heard noise and people shouted that accident has taken place, and he has seen that nano car was struck with the stem of a tree, and one lady, two children, and one accused were there in injured condition, and do not remember the complete number of the vehicle. Now Again, he has proved entire ingredients, entire scene of crime. Only he is not able to say the number of the vehicle. Now, this witness was again hostile, declared hostile. And in his cross-examination, when I have seen this cross-examination, it looks to me that the witness was clearly deposing truth. He was saying, sir, I only remember the number of the vehicle, first 2 or 3 numbers of the vehicle. HP, rest I do not remember. And he was declared hostile. What I say, gentlemen, the photograph of the vehicle was on the police file. It was a part of the charge sheet. Simply the prosecutor could have shown the photograph of the vehicle and the witness could have identified that, yes, sir, this is the vehicle in question. And you can see the number of the vehicle is also seen in the photograph. So, gentlemen, we should be very much careful while examining the witnesses. Declaring the witness hostile in a routine manner is not proper. What I say, we should live our cases. There are only few cases in which we should live. I am conducting session trial for last 10 years. And in session trials, I have also found that there are some cases which there is proper evidence. If taken care of, but as per my experience, if you have 10 cases, session trial cases, there are 2 cases in which 100% conviction will be there. And 4 cases, whatever you will do, it will result in acquittal. Now remaining 4 cases, you have to work hard on only these 4 cases. Extra work hard. Now, working hard does not mean to creating of evidence. It only means crafting of evidence. Now I would like to show you example of irrelevant facts or hearsay facts recorded by the IO in the statement of witnesses under section 161 CRP. Let us take the example. Now the statement during the investigation has been recorded by the IO in the Hindi. I will show you the translation in the English. This is the victim who was accompanying along with his maternal aunt on that ill-fated day. The age of the witness on the day when he was examined was of 13 years. Now let us see the statement recorded by the IO. I am a student of class 9th of Government Senior Secondary School. There was holidays in the school. On 15/7/2015, I along with my maternal aunt, sorry, spelling AUNT, Aunt Minu and his son were going to house of our elder maternal aunt at about 2:30 p.m. We were walking on the way. Then from our back, Machial side, a car of white color. Now, please notice, I am going and one car comes from my behind. Now the witness is saying that one car of white color came from my behind. IO is not giving the circumstances under what were those circumstances the witness has seen the color of the number. It means this is evidence, part of the statement recorded by the IO just to bring this evidence statement in streamline. To streamline the statement here, introduce these facts. Now, which hit my maternal aunt Minu, me and the son of my maternal aunt, we all fell away from the impact of the accident. I became unconscious and regained conscious in government hospital. After few days, I came to know that my maternal aunt Minu had died because of the accident. Now, फिर take care, see, which was done by the car number such. I came to know that my maternal aunt Minu had died because of the accident, which was done by car number such and such. Now, every line which has been underlined by me, it is basically recorded by the IU to streamline the statement of the witness. But you being prosecutor, we should know which facts are to be given, introduced by us through the witness. Now, in this accident, I and my and son of my maternal aunt had also suffered injuries. I came to know, now this is too much. I came to know that the car was driven by Chanchal Sen. This accident has taken place because of the rash and negligent driving of the car driver accused Prana. Now, when the witness was examined by me, this witness was examined by me. Now, I would like to ask to my friends, if the witness does not, this witness specifically, does not give the number of the car, does not state the color of the car, does not state the name of the accused, does not state that the accident took place because of the rash and negligence of the accused, will this witness be hostile? But I feel no. This minor child has spoken only facts which he has noticed. What actual facts are that he and his younger brother was accompanying his aunt, and one car, one vehicle. Actual fact is that one vehicle, because he has not seen what has hit them. One vehicle struck us from behind and we flew away because of the impact of the accident. After that, I regained the conscious in the hospital. This is the actually natural evidence. What is the need to prove the name of the accused, number of the vehicle from this witness? Need not to prove this, because what this witness will prove, that we were walking by the side of the road. Because they were walking. So he will say that we were walking by the side of the road. We were walking holding hands over our aunt. This shows the conduct of the victims. They were acting in a good faith when they were walking on the road, by the road. Now, friends, when this witness was examined, he only stated that PW8, after preliminary question, he was examined as prosecution witness. He stated that he do not remember the date and time. He, along with his maternal aunt and his cousin brother, were walking on the roadside on road. The accident has taken place, because of which he was unconscious and regained conscious at hospital. Because of this accident, he and his cousin brother sustained injuries and his maternal aunt died. We were walking on the left side of the road. Now, witness is saying whatever he has noticed. What was? Now, in the cross-examination, the facts which were underlined by me were recorded in the statement under section 161. The witness was handed over to for the cross-examination by me. I asked the learned defense counsel that, friend, you can cross-examine, but you don't need to cross-examine because the witness has not identified the accused, nor he has identified the vehicle. He said, no, there is this fact has been written in the statement under section 161. My dear friend, only statement, recorded statement does not prove our case. So he was not satisfied, but he has examined. He has in cross-examination by the accused stated that police has recorded his statement, and in the statement he did not disclose the number of the car nor the name of the driver. Further, he did not disclose to the police that the accident took place due to the rash and negligence of the driver of the accused, driving of the accused. When he has not noticed the driver, does not know the name of the driver, how he can say that the name of the driver was this and number of the vehicle was this? So, gentlemen, we should be very much careful while examining the witnesses. What I say, this is not these all things should be taught by us. A prosecutor prosecutor and a police. I am of the opinion that a prosecutor and a police can be taught by the prosecutor and the police because we are having the same bent of mind. We work in the same bent of mind for the interest of justice. So we should learn from each other and learning from each other, because what I feel that we are doing very best by every person, but that good should be brought together so that it can be made best. Now, let us see the next slide. Now, selection of witnesses. When a prosecutor is doing conference with the witnesses, he should do selection of witnesses. Which witness is to be examined and which witness is not to be examined. Now, which witnesses are to be given up? Being repetitive or formal in nature. You should not examine the entire number all witnesses listed in the list of witnesses. No. One witness from one set of evidence. You should divide your case in set of evidence. And to prove one set of evidence, you should prove that one set of evidence by one witness, not by number. So, gentlemen, if there are number of witnesses to prove one set of evidence, then you should give up one witness. You should prove your evidence by the best witness. Now, let us take the example and understand the issue. Here, I would like to take the judgment of Muhammad Khalid and others versus State of Telangana, 2024, Volume 5, Supreme Court Cases 393. Gentlemen, this is a case of NDPS. Brief facts of the case that Mr. M. Srivastava Rao, Inspector of the Police, PW1, went to
Sir, case law, please. Case law one. Case law.
Seen on the PPT, gentlemen. Is my PPT visible?
Visible.
Facts of the case that Mr. M. Srinivasan Rao, Inspector of the Police, PW1, West Zone Task Force, hereinafter referred as the Inspector PW1, claims to have received a credible information on 8th May 2009 regarding transporting of ganja by two persons from to Hyderabad in a Toyota Qualis vehicle. PW1 apprised his superior officer about such source of information and after obtaining permission, secured the presence of two punch witnesses, namely Sharif Shah and Mithun Jana. Sorry if the pronunciation of the name is not proper. To associate the punch witness, to associate as the punch witnesses and proceeded to the spot along with his team. Now, this fact clearly shows that the search was done by the investigating officer in the presence of two independent witnesses. It is very clear. Now, I have taken verbatimly the facts from the judgment of Honorable Apex Court, and the para 13 of the 14 reads as under. Gentlemen, in this case, Special Court NDPS had convicted the accused, all the four accused. And during the appeal, Honorable High Court has also convicted. The conviction was upheld. But before the Honorable Supreme Court, when the matter was argued by the learned defense counsel, it was very properly and very craftily examined. Class of examination. Argument done by the learned counsel before the Honorable Supreme Court. See, what the learned counsel for the accused argues in the court of law. Learned counsel representing accused to advance the following submissions to assail the impugned judgment and seeking acquittal for the accused. This is very important. That the independent punch witnesses associated with the search and seizure were not examined in the evidence, and hence the entire search and seizure proceeding became doubtful and are vitiated. Now, gentlemen, as a prosecutor, I cannot think of when the search was done in the presence of independent witnesses and none of them were examined during the trial. Next, let us come to the next point. That Sub-Inspector LW10, who allegedly handed over the sample packets to investigating officer PW5, was not examined in the evidence. Furthermore, the carrier constable who transmitted the samples to the FSL was also not examined by the prosecution. Further argument, gentlemen. No document pertaining to deposit of samples at the police station and the transmission thereof to the FSL was exhibited on record. The samples were forwarded to FSL after a gross delay of more than 2 months, and hence the FSL report cannot be read in evidence because the required link is missing. Gentlemen, the person who took the sample from the police station to FSL, he was not examined. And this is the very important link evidence to establish that in NDPS case, what we have to prove? That when the drug was recovered from the spot, it was properly sealed. It was properly handed over to the Malkhana. It was properly in time sent to FSL. And now, immediately it was sent to before the learned magistrate for taking of samples under section 52A. And the rules of 2022 clearly says that the sample one will directly go to FSL. So, gentlemen, the person who took that sample or sample to the FSL was not examined. Now, how can you establish the link evidence that it is the same drug has been examined in the FSL which was recovered from the possession of the accused? When this very important link is missing, I don't think prosecution is able to prove their case. Now, let us see further. Now, these arguments were submitted before the Honorable Supreme Court by the learned counsel on the behalf of accused number 1 and 2. And the other learned counsel appearing for accused number 3 and 4 urges that these accused were not found present at the spot at the time of seizure. They were arrested on 30th May 2009 merely on the basis of interrogation. Notes of A1 and A2 and were charged for the offense under section 8 read with section 20 subclause B to subclause C of NDPS Act. As the prosecution never came out with the case that the contraband was recovered from the possession of these two accused, their conviction for the offense under section 8 read with such and such of the NDPS Act is ex facie illegal and unsustainable in the court of law. Now, gentlemen, let us see what Honorable Supreme Court has held while acquitting the accused person. The two independent punch witnesses, that is Sharif Shah and Mithun Jana, who were associated in the recovery proceedings, were not examined in the evidence, and no explanation was given by the prosecution as to why they were not examined. This is very important, that there is no explanation on the part of the prosecution why they were not examined. Because non-examination of independent witness can only be under one circumstances, that the witness is not traceable or witness has died. Otherwise, if there are two independent witnesses, first becomes hostile, you are bound to examine the second. You cannot give the statement that the witness has been won over, so I will not give him. No. When the first witness is hostile, because you should know the art of cross-examination. Now, second ground, Sub-Inspector LW10, who prepared the 3 samples of ganja as per the testimony of PW5, was not examined in the evidence. In addition thereto, the prosecution neither examined any witness nor produced any document to satisfy the court regarding safekeeping of the samples, regarding right from the time of seizure till the same reached the FS. This is very important. But I was saying that the link evidence from seizure to reaching of the contraband up to FS. The official who collected the sample from the police station and carried the same to FSL was not examined at the trial. The official who collected the sample from the police station and carried the same to FSL was not examined. Now, this is clearly missing link. This is clearly a case that the report of FSL that this is ganja cannot be said that the drug recovered, any incriminating article, anything recovered from the accused was ganja, because the link is missing. You cannot say, accused, I will say, sir, it was not ganja. Under these circumstances, I will say that accused can take the defense that, sir, I agree that the recovery was done, but this is not the ganja, because prosecution is not able to establish the link between the recovery and the report of FSL. So, gentlemen, we should be very much careful while examining the witnesses. I would like to take one more example of, I am having a number of cases, but I would like to take 2 examples of such cases, because I am regularly sharing my experience with the police in police academies, what the experience which I have gained by conducting the NDPS cases in the court of law, by sharing my knowledge with the police. I have learned a lot from the police. Now, this case, Noor Agha versus State of Punjab. Gentlemen, I will request my brother prosecutors to go through these 2 judgments. You will find, you will learn a lot. Now, let us see. State of HP versus Noor Agha versus State of Punjab and others, 2008 STPL 14944 Supreme Court, or another citation is 2008 Volume 6 Supreme Court Cases 417. This case is of custom department. Gentlemen, what I feel, narcotics is a narco-terrorism against our nation. Our enemy is using our own people to destroy us. And when we know that he is enemy crossing the border, we know how to treat that enemy. But when the enemy is our own. He is my own neighbor. He is my own co-villager. I become soft. Sometimes I myself start finding loopholes in the court of law, in the law, so that he can be protected under the promise that he will not do such type of, he will not be involved in the drug trafficking in future. He will not take the drug in future. And we take a sympathetic. But dear friends, this is a narco terrorism, and the day will come, they will spoil the whole of our nation. So we should open our eye before that day comes. Because of NDPS, I have seen many things. How HIV is spreading among our youths. So friends, it is not the question that my child is not suffering. My brothers, my co-villagers is suffering from HIV, or he's suffering, he is involved in the drugs, peddling, he is a drug addict. We should have sympathy, but not on the stake of the society. Accused must be dealt as per the law. He should be brought before the court of law, before the books. Any should be granted by the court of law. We are no one to grant him immunity. If any immunity under NDPS Act is to be granted, it is to be granted by the court of law, as per the law. So friends, let us go ahead in this case. This is a case of Customs Department. Accused was charged treated for keeping 400 grams of heroin as a member of crew of Afghan Airlines. This also one of the example of part-time advocate christened as prosecutor. This is also one of the examples. Because the image initially I showed that prosecution is a profession. It is not a part-time wakalat. You cannot question a person that he is a prosecutor. Prosecution is a professional act. You should think in that manner. Prosecutor is a person who lives his life. He lives his case. It is not that entering in the court of law, taking the file, yes, who is the witness, and examining the witness. No. It is a professional. Friends, the defense counsels go through their files for the whole of night. They are working very hard. So we should also work very hard. In this case, also, Honorable Supreme Court acquitted by pointing out many serious issues which resulted in failure of the case. I would like to, my dear friends, I would like that you should go through the judgment, and the last paragraph of the judgment is very important. And in para 136 of the judgment, Honorable Supreme Court held that serious doubts are created with respect of the prosecution endeavor to prove the fact of prosecution of contraband from the appellant. In this case also, special court had convicted the accused. Honorable High Court has also convicted. But we should learn from our faults. We should not do mistakes and mistakes and mistakes and continue doing mistakes. Mistake is only acceptable once. After that, improvement. Because what I say, that the field of law is like a sea, samundar ki tarah. I cannot know everything, but if something appears in the court of law, I can say, sir, I will go through the matter and I will argue tomorrow. But such things should not become your habit, my habit. That I do. Now let us come to the next. Art of examination of a witness This is one of my case, state versus normalcy. In this case, sir, director sir, can I know what is the time up to extent of time which I
Take your own time. Take your own time. Take your own time.
Okay. Sir, then I would like to take 5 minutes break.
No, you take your own time. You complete your lecture. Take your own time.
No, I would like to take 5 minutes break, sir.
Okay. Right. Hey, లేచి ఆ తల పెట్టుకొని స్నానం చేసి రెడీగా గతం తీసుకో టైం లేదు ఇంకా బయలుదేరతా చూసుకొని ఇచ్చే మరి అక్కడ డైరెక్ట్ వెళ్తాం కదా స్నాన్ ఫంక్షన్ రా ఆరు ఉండే బాగుంది
Hello, friends. Let us join again. Hello. Is my voice audible?
Yes, sir.
Okay. Now let us start with the topic.
Audible, sir.
Now, case of Nouraga was also of the same time. In this case also, the recovery was done in the airport, and two independent witnesses in whose presence the search was done were not examined. So same story. Different, we should learn from our mistakes. Now let us come to the. This is a case of murder and rape. In this case, what I said that witness should have confidence on you. He should be properly conferenced, and we should give him moral support. That if he will speak truth, nothing will happen. I am standing for him. So this witness, in this case, a young girl, was murdered by the accused persons, two accused, and this witness came to my office as there were a number of cases of NDPS. So I requested this witness that, dear brother, I cannot examine you today, so will you cooperate with me to be examined under some next date? He said that yes. And another question I asked that, dear friend, would you like to depose because the victim deceased is not your relative and the accused might be pursuing you to not to depose in the court of law. But that witness said, no, sir, I will depose and I will depose the actual facts, what has happened. Madam, okay, friend, come to the next date. And madam, would you like that? And I clearly stated that I will not able to give you any diet money or any ticket for the conveyance allowance for the which you have come to this place. So he said, no, sir, I will manage it. Then he went back. On the next date, I have asked him to come a day before so that a proper conference can be done. I have gone through the entire file. And that witness came to my office a day before his examination. I initially asked him, you tell me what has actually happened. Then I did not showed him the statement under section 161 CRPC nor my NAB code. NAB code is a clerk given to the prosecution by the police. So he is a police constable or police head constable sometime. And at that time, a regular head constable was my NAB code. So I asked the witness to tell me what actual facts are. I did not show him the statement recorded by the investigating officer. Then he narrated me the entire facts. He was hiding one fact, and that fact was present in the police file. I requested him, dear, you should not hide anything. Do speak everything. The door is closed, and whatever you will say, it will remain in my heart. I will not tell it to anyone. But he was not disclosing that fact. After 2-3 times, he said, nothing, sir. I have disclosed you everything, and these all things has happened. Actually, in that case, the case of the brief facts are that the victim, the complainant, the witness was a married guy. He was about of 30 to 32 years of old. He was having 2 children. He was running a village shop, and in shop he used to sell vegetables, confectionaries, and the deceased used to come to his shop for the daily needs purchase. and the deceased and his sister were orphan. Their father had died and mother had left them, and they were born and brought up by his maternal uncle, Chacha. And that deceased used to visit the shop and used to purchase daily needs and come back to her house. And in due course, this witness and the complainant deceased developed the relations. And he used to fulfill her needs also, like giving some money, giving a ration, and many things. And they were in relation. When the body of the deceased was examined by the police, they have noticed biological evidence from the body of the deceased. And one of the biological evidence connected the complainant that he had the physical relation with the victim at that very time. Now, initially, the witness refused that, no, sir, it is false. I was not having any relation. My gentlemen, if you will take this stand, I will make you certain that you will be convicted. Accused will change the game against you, and he will say that, gentlemen, you were having the relation with the deceased, and she was pressing hard to marry her, and you being a married guy were not able to fulfill any promises made by you again with her, you were not in position to marry her, so you conspired to kill her. Then he was shocked. Basically, this amounts to smelling of the defense of the accused by the prosecutor. What will be the tentative defense taken by the accused? Now, after that, witness disclosed every fact, and he, yes, sir, on that very evening, we had the relations, and after that, he had gone. And in that case, it was very raining on that day, and it was the time of evening. The girl was going to her house. He took the girl in the conference with his sister of the girl. And the both, as the walk was aloof, so he was also hearing both the sisters, what the both sisters are talking. And meanwhile, he heard the voice of the deceased, and he heard the two names of the accused. The deceased said that, why you are pursuing me? And after that, they started beating her, and she clearly named them. She clearly said what the assault has been committed by the accused persons, and and these all communication by heard by the complainant and his sister. Now, these accused persons, two accused, has also committed a sexual offense with with deceased, and police had found DNA of those also. Now, the accused had the simple defense that, gentlemen, you were in the relation and you were not able to fulfill the promise, and you were not able to were not in position to marry her, so you conspired and you killed her. Now, question: the witness said, yes, sir, I will say. Now, question is when to introduce this fact, whether in examination in chief or cross examination. I took the chance. Then I said, there, because a prosecutor should not hide the evidence. You should present the evidence, entire evidence, and you should be in position to explain that evidence, why it is there. Now, I said that, gentlemen, when during the cross-examination, and I would like to say that the defense counsel was very learned with the experience about 30 years of criminal cases, conducting criminal session trials of criminal cases. He was very learned. He is a very learned man. And during the cross-examination, he asked same question. That you are married? He said, yes. You are having 2 children? Yes, sir, I am having 2 children. Gentlemen, you were in relation with the deceased. Defense counsel never expected that he will admit this fact. He said, yes, I was having that. Then he said, now the face of the counsel was perplexed. He said, put the second question, gentlemen, the girl was pressing hard on you to marry her. The witness stated, no, sir. She was not pressing hard because she knew that I am married man and having 2 children. She knew entire my background of my family and my background also. She was not pressing hard. And in this manner, we were able to block the defense of the accused. And in due course, I was transferred from that place, and both the accused were convicted by the learned Sessions Court. So this was a very interesting experience in my life, that how to block the defense of the accused. Sometimes we ignore these evidence. We try to hide these evidence. But what I say, by hiding the evidence which is on the record, you cannot escape. Court will take adverse inference, draw adverse inference under section 114G against the prosecution, because that material evidence has not been explained by you why it is there. And I have seen many a times we hide it. But how can you hide it? It is in the court file. So, gentlemen, you should not hide, but you should explain whatever is there in the file. Now, I would like to take one NDPS case, State versus Hukum Singh, and this is I teach this case in the police academies too, because now section 105 of BNSS says that the entire investigation should be videographed by the mobile by the investigating officer. During that time, this provision was not there. But in Himachal and in our entire country, investigating agencies take the photographs of the spot. But these pictures are random. What I used to, during the period of my 2.5 years of my posting in police training academy in Dro in Himachal Pradesh, I used to say that the entire investigation must be photographed by the investigator in such a manner that it should picturize the entire investigation. What I said, that the photographs must be taken in such a manner. Gentlemen, I will feel happy if everyone is opens their camera, because yes, because in the class there must be eye-to-eye contact. Hope everyone, no one is sleeping. Now let us come. I used to say that investigating officers should take the photograph of the spot in such a manner that it should picturize the entire investigation. And in my life, I have seen 2 cases in which the entire investigation was picturized. The photograph was taken in such a manner that the entire investigation was picturized. In this case, Hukum Singh, in this case, commercial quantity of drug was recovered from the rider of the motorcycle. And The search and seizure was conducted in the presence of the independent witnesses who were happened to be president of Gram Panchayat. Hope you all understand the Gram Panchayat under Panchayati Raj Act. Now, Pradhan is the most important witness. When he was examined in the court, because of his conduct, I noticed that he will not support our case. And generally in narcotics cases, witness, especially independent, not all, but generally, witness, because of their own reasons known best to them, they do not support the case of the prosecution. And the prosecutor is bound to put the question, whatever has been recorded by the investigating agency under section 161 CRPC, and by saying it is incorrect to suggest, it is incorrect to suggest, it is incorrect to suggest. And every suggestion is because every suggestion is denied by the witness. Now in this case, it is a case where I would like to show the statement of the witness, where the witness stated that nothing has happened in my presence. Police has taken my signature on certain documents and no recovery was present in my has happened in my presence. Now I would like to show the state. I will not show the photographs because this is an open webinar. These photographs are shown by me in the classrooms, which I used to take for the police and prosecution too. But I will show you the statement. Show you the statement. Now, please see. Stated that I am Pradhan of Gram Panchayat. Important are the underlined and redlined. We met the police official who were present there. Accused present in the court today was also present there. Police took signatures on 4 to 5 documents and no piece of on a piece of cloth paper. I asked him whether any government official except the police had come there. He said no. No other government official came on the spot in our presence. Now, this cross-examination, when I cross-examined the witness, now cross-examination, the witness never expected that the photograph will be shown to him during the cross-examination. Now, see that he was consecutively elected second time as a president of the panchayat, and when I suggested it is incorrect to suggest that I have signed this memo after going through the contents of this memo, it is correct to suggest that I always sign the documents of the panchayat given to me by the secretary Gram Panchayat after going through the contents of the same. Self-stated that those documents are dictated by me. Now it is correct to suggest that I know Tahsildar Amb. Now in this case, actually what has happened? The drug was recovered in the presence of these two witnesses. As the recovery of the drug was in commercial nature, IU had become suspicious that he might be carrying the drugs in his persons also. And persons as defined under section 50 of NDPS Act in Baldev Singh versus State of Punjab versus Baldev Singh and State of HP versus Pawan Kumar. So IU became suspicious that he might be carrying any drug in his persons. So he apprised the accused with his right under section 50 of NDPS Act that, gentleman, I suspect that you might be carrying the drugs in your body, person, and you are having a legal right to be got searched in the presence of authorized gazetted officer or a magistrate. And this accused opted that I would like to be examined in the presence of an authorized gazetted officer. Now the investigating officer requested the Tahsildar Tahsildar, being a gazetted revenue officer, came on the spot. So I asked him, before showing the pictures, gentlemen, you being Panchayat Pradhan, you might be visiting the Tahsil regularly, so you might be knowing Shri Shri M. Tahsildar. He said, yes, I know him very well. So that when I show the picture, he should not say that I don't recognize him. He was fixed by me. Now, let us. In blue, he says it is incorrect that on the search of the bag attached with the motorcycle, 2 carry bags were recovered. Now, what he says, it is incorrect. Now, I showed him the picture. Now, you can see the difference in red line. It is correct to suggest that in photograph mark P2, I am present with the police when the search of the bag tied to the motorcycle of the accused is being carried out by the police. It is correct to suggest that in the said photograph mark P2, driver RK is also present, who is wearing check shirt, and the accused HS is sitting on the motorcycle. Now, you can say in the court, these are the facts sufficient that the prosecution case is true. Witness is deposing false for the reasons best known to him. Until date, we are not able, only defense in Indian NDPS case is that no recovery was done in my presence. Every document was got signed by the police in the police station. And we are not able to break this defense, block this defense since 1980. Now let us come. The charas was 1 kg and 989 grams recovered from the possession of the accused. So commercial quantity. Now let us. In blue line, it is correct to say that upon the request made by the police officials present on the spot, Tahsildar Shri M arrived on the spot. What he says, incorrect. He says incorrect to say that Tahsildar has come on the spot. It is incorrect to say that in our presence, Tahsildar Sahib made his endorsement on exhibit such and directed the police official to search the accused in his presence. When I am asking the witness simply question that has this fact occurred in your presence, it denies. Where when I show the picture, story is something different. It is incorrect to suggest that in the presence of the Tahsildar Shri M and in our presence, firstly accused searched the police official present on the spot and the IO kit. Now, the Tahsildar gave the option to the accused that, gentlemen, before you are searched by the police, you are having the right to search the investigating officer and their kit in my presence. Now, what witness says, it is incorrect. He says it is incorrect that accused has searched, the Tahsildar has shown him that right and apprised him for his right, and he has searched the police officials. Now, let me show you again the difference. In red, it is correct to say that in photograph mark P9, accused can be seen personally searching IO on the spot in the presence of the Tahsildar. Now, you can see the difference. Gentlemen, what I want to say that in routine we are exhibiting the photographs. But question is how to prove, how the art of proving, showing the evidence, photograph to the witness. In routine, the person who takes the photograph, he comes and says that in the spot and such date I have taken the photographs and these are the exhibits. Nothing. I am not saying that my brother prosecutors might be doing these all things. But we should do one more of it. More. It is correct to say that accused was personally, it is again says the key in blue, It is incorrect to say that accused was personally searched in our presence and in the presence of the Sildar. See, the conduct of the witness. He is a president of panchayat. He is not able to think that he will again show the picture. Now see, it is incorrect to say that accused was personally searched in our presence and in presence of the Sildar. Now when I showed him the picture, he says, now see the scenario. It is correct to suggest that in photograph mark P7, IO can be seen personally searching the accused in my presence as well as in the presence of the Sildar and other police officials. See the difference. Again in blue line, it is incorrect to say that I signed the document, that is memo exhibit PW1 oblique B and exhibit PW1 oblique C in the presence of the Sildar on the spot. Again he says incorrect. It again, when I showed the photograph, now see the difference. It is correct to suggest that in photograph mark P8, I can be seen signing the document in this case in the presence of the Sildar, accused and police officials. It is correct to say that in photograph mark P5, driver RK could be seen signing the document on the spot in my presence and in the presence of the Sildar, accused and the police officials. Now, gentlemen, you can see the difference. If we are able to lead our evidence properly, you can extract many things from the mouth of the hostile witness. That is why, gentlemen, I have said that you should respect the witness. He is our guest. We should not behave with the witness in an inimical manner. He is our guest. Give him proper respect you give to a guest. Because we should know the art how to extract the truth. That is important. Instead of learning that thing, we start threatening the witness. This will happen, this will happen. No. It is our duty to respect them. We should give a proper environment to the witness. So that the factor of fear should go away. We should feel him important. That gentleman, you are the person because of which a justice can happen. Society can be benefited because of your evidence. Otherwise, it is very easy to discuss that in our house that nothing happens. Police is doing nothing. Prosecution is doing nothing. By having a cup of tea, we all do such type of discussion. Police is doing nothing. Prosecution is doing nothing. What I say, that very few of us are guiding to the police. What we say, that is, it is not our duty to guide the police. No. Gentlemen, whatever is to be collected by the IO is to be presented in the court of law by us. If we are not able to guide, we are not guiding the police, then the rubbish will be collected and we will fight for the rubbish. It is same like computer. If refined data is entered, computer will give you a best result. The rubbish you enter, rubbish you get. So, gentlemen, whenever a police asks you wants to seek any guidance, you should guide him. Now, State versus Kashmir. This was a case when I was posted as an IPP, public assistant district attorney, and I would like to make say here that in our state, in Himachal and Punjab, we are basically appointed as an assistant district attorney. Attorney means to conduct the civil cases of civil litigation of the state also. So we are appointed as assistant district attorney. By virtue of that post, we are notified as an assistant public prosecutor to conduct the criminal cases also. And because of appointment as an assistant district attorney, our promotion is AD, assistant district attorney. Second promotion, first promotion is deputy district attorney. Second promotion is the district attorney. District attorney is a head of the district who controls the prosecution of in the level of district. He is the district head of the prosecution, and the entire prosecuting officers in his districts are controlled by him. He writes the ACRs of his prosecutors. He writes the ACRs of his ministerial staff. So he is just like SP in the district. After that, among district attorneys, we are promoted as joint directors. In our state, there are 7 joint directors and director from cadre officer as a director of prosecution. So this case, State versus Kashmir Singh, and one civil case also. I'm trying to collect the data of that case also because I'm not able to collect the evidence part of the statements of the case. So that is a civil case. So I would not like to discuss that case with you all, but I would like to discuss this case. This is a very important case. In this case, a small child of about 8 to 9 years to 10 years was sleeping in, I would like to show you the picture. This is not the actual picture, such type of house. He was sleeping in the veranda of the house. And their neighbors started fighting with the parents of the child. And one of the accused hit one piece of khapra. Khapra means a clay roof tile, which I will show you the roof, clay roof. Hope I am able to make you understand. And such type of pieces. Broken piece of clay roof. And small triangle piece was hit by one of the accused, and it straight away hit the eye of the sleeping boy. Now the child immediately started weeping. He was sleeping. Child started weeping. Mother took that child immediately to the hospital. And this witness, PW6, was witness to the fact that he had arrived on the spot and he noticed that the mother of the child was weeping and the mother was carrying the child in her lap. And he asked what has happened, that, and she disclosed that my child has suffered an injury in his eye and blood is oozing out. So he helped that mother to take her along with the child to the hospital. Only this part was witnessed by this PW6. Now, this case was very properly conducted. Everyone was deposing very properly. But this PW6 came to the hands of the accused persons. And the accused very smartly tutored him. Accused very smartly tutored him, and he said that in examination in chief, he said that mother and father of the victim child were fighting with each other, and father of the child, and he also gave a suggestion that the father is not the real father of the child, he is a stepfather of the child, and he was fighting with the mother of the child, and under the drunken condition he threw a piece of stone which directly hit the eye of the child, because of which the victim was injured. Now, a story has been narrated by under very proper story, and if not rebutted, it will spoil our case. Now, what I feel, first you should take the witness in confidence that you are speaking true. Gentlemen, you are right. You are right. And I asked him, first question, very after I declared him hostile, and very first question, gentlemen, you are co-villager? Yes. Do you recognize the all accused persons? Well, yes, sir. I all recognize all these all persons. Do you recognize the family of the victim? Yes, sir. I recognize the victim and his parents also. The accused persons, I do not say, I asked him that these persons standing in the court, namely A, B, C, D, E, F, were standing there at that relevant time when you were present there? Yes, sir, they were standing. Now, what I have proved, the presence of accused person on the spot from a hostile witness. Now, the question remains that the father, stepfather, has hit a stone which directly hit the eye, and victim had suffered the injury. Now, the witness, I took the witness in very much confidence that you are speaking true, gentlemen. Yes, you are very right. Now, gentlemen, please, can you tell me how big was the stone? Because I know the modus operandi. I know what can be tutored. And you should be able in position what can be tutored. I was of the opinion that he has been tutored, that a stone has been directly hit and nothing else. I asked him, can you tell me how big was the stone? And I asked the witness to look in my eyes. Now, this fact was not tutored by the accused. Now the witness was confused. I started shaking my hand in this manner. When I said the stone was round, he said, yes, sir, stone was round. Then I asked another question. The weight of the stone might be of 1 kg. I was moving my hand in this manner, and I asked, gentlemen, the weight of the stone might be of 1 kg. He said, yes, sir. The stone was of 1 kg. Now another question I asked. Gentlemen, the father, as you have seen the spot, the stone was directly the eye of the victim. Yes, sir. The stone directly hit the eye of the victim. Now, gentlemen, as per medical legal report, MLC, medical legal certificate, there was no corroborating injuries on the eyebrow. Victim has suffered the injury in the retina of the eye, because of which the child has become blind, and the blood was oozing out from that. Now I ask, gentlemen, you are speaking lie. Because if a stone having round shape, weighing 1 kg, would have directly hit the eye of the victim, then it would have fractured these parts of it. Then the witness was in the fix. He was not having any answer. During now, he denied these all suggestions of mine, but crux is that I was in position to rebut the story, second thought story prepared by the defense, by the accused. In this case, one more thing was important, that the blood-stained clothes were not taken by the police during the investigation in possession. Now again, not taking the blood clothes in the possession and proving in the court of law will also amount to drawing of adverse inference against the accused, against the prosecution. Now what I said, that everything is to be explained. Presence of evidence and absence of evidence. Here clothes were not present. So absence of evidence, physical. This fact was narrated by the mother of the victim, that I am very poor lady and having only one shirt. When I took my child to the hospital, my child was referred to the further hospital for the management, and I was having no shirt to change. So I took out the shirt of my child, washed it as it was summer. The shirt was dried, and I took the child, my child, in that shirt. Now prosecution has given the explanation why that blood-stained shirt is not produced in the court of law. During the argument, learned magistrate was very humble, very nice, very learned magistrate. He said, only question, dear prosecutor, what is the explanation? Accused is saying that a shirt has not been produced by you in the court. On that day, on the day of argument, mother and victim were also present in the court. What I say, friends, when you are doing the work in the proper manner, in the interest of justice for all the people, God comes to help you. The child came in the court, was in his school uniform. Now the learned magistrate asked me, it is the same scenario pan-India. Learned magistrate asked me, Mr. Prosecutor, why the shirt is not taken by the police in the as an evidence, piece of evidence. I replied, sir, that to be a poor is not a curse in this nation. Witness has clearly stated in her examination in chief that I was having only one shirt and it was soiled with the blood. So I washed it and took my child to the further management, to the further hospital. Now I have brought the notice in the notice of the learned magistrate, sir, today the child has also come in the court also. And whenever I go to certain place and that to court, I will come in my best uniform, best dress available with me. And the best dress available with the victim is the uniform provided by the school. So, sir, the absence of evidence has been duly explained by the prosecution. And this fact was properly appreciated by the learned magistrate in his judgment, and accused was convicted. So, friends, what I say that we should know, we should explain why the evidence is there in the case. DNA evidence was present against the complainant. Why that is present here? Why it is not present? Under both circumstances, prosecutor is duty bound to explain, not to hide the evidence. If you will hide the evidence, adverse inference will be drawn against you under section 114G. And no one can protect your case if the learned court draws an adverse inference against you. And this is such fact which cannot be cured at appellate stage also. Because time has gone. Now, let us come to another case of mine. I am having number of cases, and dear brother prosecutors, I can speak for whole of the day, but because of certain limitation of the time also, I cannot speak for the whole of the day. So I will definitely take some cases more. Hope you understand the piece which has hit the eye of the child. This is such type of small piece. Now a case of POSCO. Protection of children from sexual offences. Generally, I have seen in the case of POSCO, the main defense of the accused is that the relation was committed with the consent of the victim. Only available defense with the accused is that the relation was committed with the consent of the victim, if the case of the prosecution is supported by the scientific evidence. Otherwise, other modus operandi is to bribe the witness or turn her hostile. The witness turns hostile. Second operandi is marry the victim. Honorable Supreme Court has very clearly said this is not the way. Marrying the victim does not condone the offense. Because to escape from the clutches of the law, today accused is promising or marrying the victim. How it can be taken granted that he will respect the victim for whole his life? Because the person who cannot respect the girls, how he can be expected to respect the woman after the marriage? Our ancestors has taught us to worship the girls in Navratras, to treat the young girls as Navdurga. That is why we are worshipping the young girls in the Navratras, so that we can teach our young boys that girls are Devi Swarup, Durga. Very good teaching given by our ancestors. but we have forgot to follow our ancestors. We say, what is the fun of worshipping the girls in Navaratras? Basic intention of worshipping the girls in Navaratra is to telling our boys to respect the girl as Devi. So friends, and the other defense, in mostly cases, accused tries to take the defense that the relation is with the consent and the age of the victim is major. She is not minor. She is major. Now, in one of my case, accused tried to make the 11-year girls major. 11-year girl major. In this case, victim and accused both were migrant laborers. And family of the victim came to my office, and in Himachal Pradesh, we are assisted by a lady constable who is known as Pairvi officer to assist the female child or victims for the sexual offences. Because I am of the certain view that a female child is not open to male under all circumstances. Even my daughter is not open to me. He will open her heart to the mother or to any female, but he is not comfortable to open her heart to the male. I would like to give one of the example. When I was posted as assistant prosecutor, at that time, before 2012 era, at that time there was no POSCO Act, and the offence was covered under section 354 of the IPC. Briefly, the case is that the family was well-to-do family, and it was the occasion that his mama, maternal uncle's marriage was happening, and because of sound of marriage, it was difficult to hear. The victim went to the bathroom, as the bathroom was of old culture, hook, not proper bolting system. Accused entered the bathroom and assaulted the victim. Now victim came out of the bathroom and she first met to her maternal grandfather, Nana. And she only disclosed that such and such accused has assaulted me. Now, paternal grandfather became angry and he thought that left the marriage, first the matter should be reported to them. Now he took her granddaughter and came to the police station. See the irony, when he reached the police station, the entire staff was male. And the SHO to whom the matter was reported, he was male. SHO was very kind enough, very nice gentleman. He made an application to the doctor for the medical examination. Now, again irony, when they reached to the hospital, the doctor was also male. But doctor was very kind enough. He referred the matter to the lady doctor and that to gynecologist. And medical examination was done and charge sheet was filed. Now, during the trial, when the victim appeared in the court of law, she was in about 8th or 9th. And the judicial magistrate was very humble, very humble. The trial was conducted, but he called a lady advocate to assist the victim. And learned magistrate, as he was very humble, the victim was not able to speak what actually has happened. Learned magistrate asked the victim, Beta, write what has happened to you. You don't try to speak. Write it on a piece of paper. And he signed the paper and asked the victim to write on this paper what has actually happened to you. Now, that very moment, the victim actually wrote what was actually happened to her. Now, it was very easy for the defense to break the evidence written by the victim, because he simply asked. Defense counsel was very humble. I would like to appreciate the defense counsel also. He did not ask any rubbish questions. He straightaway said, "Dear child, you are accompanied by your parents." Like, yes. Your mother has tutored these all things to speak in the court of law. Otherwise, these all things has not happened. The victim said, "No, sir, it is incorrect to say that." And but he was in position to introduce in the court of law that this is second thought. This is not actually has happened. At the time of argument, it was shown through records that it was the irony that there was no police official. After that, the matter was taken up by me also, and all the police staff, lady constables were also posted. And after that, but there might be some many police stations where lady police officers would be posted, but at that time, in that police station, lady police officer was not present. So, but after that, by SP, it was ensured that in all police stations, lady constables are posted. Now, let us come to this case. In this case, victim date of birth was 11/11/2011, and basically, mother and father were only telling the date of birth 11 date and year 11. They were speaking the month in Hindi months, Baisakh, Asad. And from the calendar, I came to know that which month is this. So it was 11/11/2011. Now the counsel was so smart, he confused the Now, during the conference, as the victim has disclosed the entire story to her mother, and mother has narrated the story to her husband. So, and the complainant was also mother. So I thought that the mother should be examined, and I will give up the father being repeated. This was my selection of witness. Now, during the cross-examination, counsel of the accused was very smart and trapped the complainant, and in the anger, she started speaking her kuch, everything, which was irrelevant. You don't know ye wo hai. And in that heat of moment, the counsel of the accused started important questions to the witness. What? This witness was illiterate, and during cross-examination, she said that she was married to her when she was minor. And in anger, question was asked that your marriage took place in 1996. She said, yes. What you will say? Yes, it happened in 1996. What you will say? What you can do? Tell me. And this answer in the fit of anger was recorded by the court. And next question he asked that after the marriage of 2 years of the marriage, your first daughter, that is victim, was born? She said yes. Now, gentlemen's occurrence is of winter of 2020. Winter of 2020. Date of birth is 11/11/2011. Now, what the accused said? That your marriage has taken place when you were minor. It was the year 1996, and within 2 years of marriage, the child was born. Now, this means that the date of birth of the child is of 1998, and the age of the child is 22 years. How smartly he turned the table, and he made 11 years child 22 years. Now, question is, should we surrender? No, we should not surrender. The witness father, which I thought to give him up, I took the decision that he should be examined in the court. After the examination of the mother, I called the father, and initial introduction was that my name is such and such, my name is such and such, I am a father, son of Flana Flana, and resident of Flana Flana, and my age is 32 years. Means on the day of examination, the age of the father is 32 years. And on oath, I started examining him, and I simply asked, gentlemen, how many children you are having? He answered that I am having 5 children. From whom? He said that the witness A is my wife, and I have begotten 5 children from my wife. It means complainant is the mother and I am the father, and we are having the 5 children. Men and gentlemen, what was your age when you were married? This fact was never in my mind while I was doing conference, but it was my good luck. The witness to my answer, I said, what was your age at the time of your marriage? He said, sir, my age was 18 years when I was married. Gentlemen, hope I rebutted the defense taken by the accused that the victim is major. Because if we take on the date 20 in the year 2021, the witness was examined. On that day, the witness is of 32 years. On the date of marriage, he was 18 years. Now, after 2 years of marriage, child was begotten. Means 18 minus 32, 16. 16 minus 2, 14. Under all circumstances, child is not more than 14 years. Again, minor. Now, in POSCO, first ingredient to be proved by the prosecution is that victim is minor. So, I have proved the ingredient by the evidence. So, we should be very smart enough. We should be vigilant how the defense is taken and how to rebut. That is why I said that examining the criminal file is like playing a chess. You should know the tentative moves to be made by the accused. You should be able to block the defense. Your presence of mind should be such a sharp that you should be in position to block the defenses taken by the accused, which was not expected by you. You must be smart. So, let us come to One of my brother has raised his hand. He can ask the question, please. One of my brother has raised the hand. Please ask the question. Should yes. Yes.
Sauri, Mr. Sauri, you have raised your hand. That's why he's asking. Mr. Sauri. Mr. Sauri. SS Sauri, Assistant Public Prosecutor, Guntur, raise your hand. Okay, sir, you continue. They might have inadvertently raised their hand. You complete it.
By mistake, he might have raised his hand.
Okay, okay.
Let
you
us
complete
continue.
It seems Mr. Sauri is sleeping. That's why he's not responding. That's why he raised his hand also, he's not responding.
Yes, I am sleeping.
Okay, okay, you carry on.
Now let us come.
Sir, unmute your mic. Unmute your mic, sir, between.
Yes. I'm audible.
Yeah.
Now, how to prove the voice in the court of law? This is very important fact. As we all know that as per the judgment of the Honorable Supreme Court, voice sample is to be taken in the presence of the magistrate by moving the application. And sample is to be taken by the expert, not by the police in his mobile. No. You should call the expert, or magistrate should direct the expert to take the samples in the scientific manner. IA should not start recording the voice sample in the court of law by moving the application. The learned magistrate allowed, and the IU starts the recording the voice sample in his mobile. No, this is not the way. Voice sample should be recorded by the expert by calling him in the court of law, or by the order of the court sending the witness to the expert. Now, in a case, I would like to the extract taken from this judgment of the Honorable High Court is that in this case, Sanjeev Kumar PW8 stated that in his cross-examination that he recognized the voice of the accused on the telephone, but he did not mention how he could have identified the voice of the accused. This is very important. Simply saying that I recognize the voice of Flana A, it is not sufficient. Witness has to depose how he was in position to recognize. For example, he is my friend, he is my mother. The case in Kashmir, my case, I recognize the voice of the deceased because she happened to be my friend. So, gentlemen, we should properly explain how I was in position to identify the voice. Similar is for the handwriting also. This is the handwriting of A. How do you come to know that it is the handwriting of A? There must be explanation. This is explication of my junior. He is my clerk, and routinely I examine his files, and because of which I know that this document is written by Mr. A. This shows from where the knowledge has been derived. This is very important. When you are not able to show in the court of the law that from where the knowledge is derived, from how I come to know that the voice is of A, how I come to know that the handwriting is written by the A, it cannot be proved in the court. Handwriting cannot be proved merely by the FSL report. It should be corroborated by the person who can identify the handwriting. That I am in position to identify the handwriting because I have routinely examined his files. He is my son. That is why I am in able position to identify his voice, identify his handwriting. Now, future of the crime is digital crime. And I'm really very thankful to Director Prosecution of Andhra Pradesh that he has taken such a good step. And because future of the crime is digital, and in present scenario, no one is talking of digital crime. Everyone is saying, investigating agency is saying that in this way, crime is committed. But how to prove in the court of law? Prosecution should know, and investigating officer should know how to investigate the digital crime. They are showing in their presentations how we arrested the accused, how the money was recovered in the money frauds. But how to prove it? That is very important. Bharatiya Sakshya Sanhita basically addresses the future of the crime, new generation crime, digital crime. And we are not, if we are not well versed with the method of proving the digital crime, we will be dummies in the court. And we should know properly know section 105 of BNSS, Bharatiya Nagarik Suraksha Sanhita. And as we all know that evidence must be proved by the primary evidence. So what is the definition of primary evidence? For the digital evidence, primary evidence has been defined by the Bharatiya Sakshya Sanhita. Before that, I would like to come to BNS, Bharatiya Nagarik Sanhita. Section 1, subclause 5, subclause C of BNS 2023 has introduced a new fact in accepting the digital crime. It says any person in any place without and beyond India committing offense targeting a computer resource located in India. Now, IPC, BNS is prepared to nab the accused under IPC or BNS who are targeting our computers boundaryless. Investigating agency will go and nab the accused. Forensics will tell the method of crime. But question is how to prove. Impact in the society is deterrent in the society is because one acquittal boosts the moral of the hundreds of the accused. That nothing happens. कुछ नहीं होता. Continue doing crime. Nothing happens. कुछ नहीं होता. This is the moral booster to commit again and again and again the crime, and specifically digital crime. Just a minute. I have to take a call. Basically, I am in New Delhi and taking a class from Himachal Bhavan because I am here for last 1 week as I am posted in higher education and I have to come here to file an SLP in a state litigation in a very important matter. So my superintendent is calling me, but no matter. I have said that class is continuing. Now, IPC and CRPC says how to nab them, how to investigate them. Evidence Act, how to collect the evidence, how to prove it. Now here is the prosecutor. That is why I say a person named as a prosecutor, my boy, you are a prosecutor. No, this will not do. Prosecution means professional prosecution. A advocate, a new boy is to be inducted in the prosecution department, prosecution cadre. He is to be trained like a soldier in the prosecution department, prosecution academies, so that he could stand against the adverse, against the defense. He should not feel tiny in front of the accused. Tiny from his brain. That is why crime of the future is digital crime. So now what I was saying, now how to prove digital evidence? Now section 57 Bharatiya Sakshya Adhinam defines or tells primary evidence. What is primary evidence? As we all know that the case is to be proved by the primary evidence. Now explanation 4 gives the certain circumstances that how to prove these all cases. So gentlemen, basically I am giving a next topic to Worthy Director Prosecution Andhra Pradesh that a webinar should be conducted on and topic should be how to prove digital evidence in the court. Because everyone is saying how to nab, how to nab. This is crime. If you are sharing OTP, your money will go. But how to prove it in the court of law? That is very important. So, gentlemen, here I would like to close my presentation and I will be very happy to answer the questions from my learned friends.
Thank you, Bikchand Garu. Anybody want to ask questions or queries, you can ask.
Sir, good morning, sir. This is Lakshman from Gutti, sir.
Jay, please.
I have a question, sir.
Continue.
Sir, could you hear me, sir?
Yes, I can hear you.
Yes, sir. Sir, what was happened in one murder case? In the morning, he was supported the case of prostitution fully. After lunch, he was totally went to the cross-examination of defense counsel. Now, what I have to conduct, re-examination I have to conduct or the cross? That is the question.
Gentlemen, you are basically such type of witness who initially in chief support the prosecution and in prosecution it supports the accused. Such type of witnesses are of no use. Because if you can only declare him hostile, get the request the court to declare him hostile, And if court allows and declares the witness hostile, you can cross-examine to the extent that why you have deposing false. Bus. You cannot put the entire story. You have to say that under what you can tell him or ask him under what compelling circumstances or during lunch period he has bribed you or something. Or in other case, I would like to tell my brother friends that if once the trial is started, it should finish when the cross-examination finishes. In one of my murder case, examination in chief of the IO was conducted for the 4 days, continuous 4 days. And on 5th day, half day case property was shown, and learned session judge did not allow the lunch and asked the defense counsel to cross-examine the witness. And the learned defense counsel was very intelligent. He did not took that so much time, and within 1 hour he wrapped this cross-examination. Otherwise, sometimes they also take very long cross-examination. So in such type of circumstances, what I say that witness should not be deferred, as this it is the judgment of Honorable Supreme Court that once the witness appears in the court of law, he cannot be deferred. He is to be examined and he is to be cross-examined. Sometimes I have seen that examination is chief is done, cross-examination is deferred. No, it is not possible. Supreme Court clearly says that once the witness comes in the court, his examination and cross-examination is to be done in the one day.
Thank you, sir.
ఏంటి లక్ష్మణ నీకు ఇప్పుడు క్రాస్ ఎగ్జామినేషన్ అయిపోయిన తర్వాత హాస్టల్ ఎలా డిక్లేర్ చేయాలని అదే కదా ఈ క్వశ్చన్
చీఫ్ లో సపోర్ట్ చేశాడు సార్ ఉదయం
ఈ సపోర్టెడ్ ఇన్ చీఫ్ అండ్ ఇన్ క్రాస్ ఎగ్జామినేషన్ టర్న్ హాస్టైల్ whether you have to declare hostile in
such type of practice happens in our state also, sir.
Then there is Supreme Court judgment in re-examination also you request the court to declare the witness hostile and permit the court to declare the witness hostile. You can cross examination. You can go need not go for again for chief examination to declare the witness hostile. That is your point, I think. Adena?
Yes. You have to request the court to declare him hostile.
Emandi?
Absolutely.
There is a Supreme Court in 1956 or so judgment is there. You can declare witness hostile in even re-examination also. You need not go again to back for chief examination.
Yes.
Generally, people will think that we have to recall the witness for chief examination, then only we have to recall the declare the witness hostile. That's not the correct. Immediately after cross examination, in re-examination, permit the court to re-examine, explaining the reasons for to declare the hostile witness, and the court will permit you for hostile, and in re-examination you can ask questions which have to be put as by way of cross examination.
The first re-examination చేసిన తర్వాత మళ్ళీ again I have to request the court for further cross examination. Then I have to
immediately after cross examination we have to explain the court in the chief examination he supported the case of the prosecution, whereas in the cross examination he did not support the case of one turn again over by the accused. That's why we intended to cross examine the witness and permit me to declare the witness hostile. The court will declare the hostile, then you can put the questions which are by way of cross examination in re-examination itself. What is the difference between chief examination and cross examination? You are not expected to ask leading questions.
Understand? Yes, sir. That is the yes, sir.
Yes, you can ask even in somebody is crossing voice. You can put the questions by way of cross examination, re-examination also. Bar is only can't put leading questions in chief examination. But whereas in cross examination you can put the leading questions while declare the hostile the witness.
Sir.
Right. Okay, understand?
Sir, ఒక్కసారి జడ్జిమెంట్ ఏమైనా ఫర్నిష్ చేస్తే
అంటే నా దగ్గర ఏమి ఉండదు కదా. బై ప్రాక్టీస్ ఐ విల్ షేర్ ఇట్ టుమారో. ఓకే.
లక్ష్మీనారాయణ ఓబి సత్యనారాయణ వర్సెస్ స్టేట్ ఆఫ్ ఏపీ ఉంది చూడమ్మా.
సార్ పబ్బి సత్యనారాయణ వర్సెస్ స్టేట్ ఆఫ్ ఏపీ అది ఓన్లీ ఇట్ కెన్ బి
చెప్పేది ఖజాన్రా గారు, అది క్రాస్ ఎగ్జామినేషన్ లో వ్యాలిడిటీ దాని గురించి అది కాదు, రీ ఎగ్జామినేషన్ లో క్రాస్ చేయొచ్చని.
అంటే దీనికి కూడా ఉంది సార్, దయాబాయి చక్కన్బాయి వర్సెస్ స్టేట్ ఆఫ్ గుజరాత్ అని ఉంది సార్, 1964 లో ఉంది.
అదే సమ్ జడ్జ్మెంట్ ఇస్ దేర్, యు కెన్ షేర్ ఇట్. యు షేర్ ఇట్. ఓకే, రైట్. నెక్స్ట్ క్వశ్చన్, అదర్ క్వశ్చన్స్ ఇస్ దేర్. సురేఖ
Sir, namaste, sir. My name is Surekha, sir, working as an ATP advocate, sir. Sir, my voice is audible, sir. Can I say? Sir, can I
Yes,
say,
please,
sir?
please
Please.
continue. Yes, continue your question.
Thank you, sir. Sir, I have doubt regarding to the at the time of cross-examination, if another advocate who is not in his memo of appearance is now assisting the another advocate who is crossing the witnesses, it is possible without the appearance memo of appearance of the another advocate can assist the witness can assist the another advocate at the time of cross.
In our state in Himachal Pradesh, I don't think there is any memo of appearance on the behalf of accused by the counsel. Because power of attorney is relevant in civil cases only.
Yes, sir.
In criminal cases, if the accused, because the presence of the accused is important, and the accused is standing with what, in my opinion, I am standing for the state, for the victim. How many number of counsel he can bring?
Madam,
Sir, I am
12,
stating
13,
that
Madam,
the defense
Madam.
counsel, sir.
Madam,
Yes,
you
sir.
see, only memo appearance has to be filed for the right to audience on behalf of the accused.
Yes, sir. Accused itself,
No
sir.
memo,
If another
no
advocate is
memo.
interfered.
See, madam, the
Yes,
advocate
sir.
who has not filed memo has no right to audience with the court, but he can assist his senior
Yes, sir.
person. Okay. He has no right to audience
Sir,
with
at
the court
the
when he is not filed memo of appearance or wakal.
yes, sir. Thank you, sir.
Right. Next, Nagaraj garu.
Sir, good afternoon, sir.
Yes, yes.
Sir, good afternoon, Speaker, sir.
Good afternoon.
Sir, I have a query with regard to the one. It's a case of a murder case, Your Honor, a murder case, sir. So it is reliable on last scene theory, sir. So wherein PW 1 to 6 was stated that a sniffer dog has been brought and it has been identified the house of the accused. And whereas in charge sheet only a single line has been noted by the investigation officer that sniffer dog has been brought and it has shown the house.
Please repeat your question because some mistake, technical error occurred and I was disconnected.
Sir, it's a case of a murder, sir, relied upon last scene theory, sir.
Okay.
So PW 1 to 6 were examined in the court and they said that a sniffer dog was brought by the police after the inquest.
Okay.
So and subsequently when I gone through, before that a simple line has been mentioned in the charge sheet by the investigation officer that a sniffer dog was brought and it has shown the house of the accused. And he has not list of witnesses, he has not mentioned any name of the handler of the sniffer dogs.
So how will you prove the evidence of the dog?
So that's what, can I file a 311 petition, sir, asking the Honorable Court to take the evidence of sniffer dog holder?
Yes,
handler.
definitely you have to file application under 311 CRPC.
So will it be helpful for the prosecution, sir?
Definitely. But when you will examine this handler of the dog, you should first handler of the dog will explain the qualities of the dog for which this dog has been trained.
Sir, it has
Because
been
every dog is trained for different acts. For some dogs
Okay,
are
next
dogs
Ramanjal
are
garu.
trained for drug
Ramanjal
detection.
garu. Okay, Nagaraj garu, చెప్పారు కదా, you file 311 petition.
Okay, sir. Thank you, sir.
If you have any doubt, you contact Deputy Director or with our office. Okay, next Ramanjal
Sir,
garu.
please, sir.
Sir, one small doubt here, sir, requesting. In robbery, rape and murder cases, sir, circumstantial evidence are linked, sir. And also CC footage is also, all circumstantial evidence is also linked here, sir. But the character of the criminal background of the accused, we should not find అంటే ఎవిడెన్స్ లో చూపించలేదండి. we exhibit the character of the accused, case crimes did not evidence treated.
His question is conduct of the accused has to be adduced in evidence as a circumstantial evidence. Yes, that is his question.
Yes.
Why not?
అది అలా
Conduct under Section 8 of Evidence Act is relevant of accused as well as of witness also.
Okay, sir.
Everyone's conduct is relevant under Section 8 of Evidence Act.
8 of Evidence Act. Okay.
Previous conduct of a accused can be given in reply. If
Barkat,
accused,
do you want to ask any questions?
Thank you, sir.
Barkat?
yes.
Yeah, okay, ask.
There is a long gap, sir. There is a long gap. Chief and cross over, he supported the prosecution case. Now, after a long gap of 1 year, the witness is recalled again by the accused side. Now he supports the entire version of the accused side.
What allowed such application?
Was allowed.
Once the witness was examined and re-examined,
Cross-examined.
Prosecution should have opposed the application.
Opposed. In spite of that, the judge has allowed the petition, 311 CRPC petitioner. And what is the valid evidentiary value of that evidence which has been recorded after a long gap of time?
You can argue that after a long gap, it is a second thought and the witness has been won over.
We can also cross
evidence recorded initially on 1 year earlier.
That's why Bishnu Chandra has already told you that the cross examination and chief examination has to be done in the same day. If the court time is over by 5 minutes, it has to be continued on the next day. That is the directions of the Supreme Court. It is a fault on us giving time to the accused for cross examination for number of occasions. You see in future that no time shall be given for the cross examination by the court by showing the judgment of Supreme Court. Okay.
Agreed, sir.
Right.
Agreed, sir.
Next.
But previous prosecutor did it.
See, whatever prosecutor, instead of pinpointing us, you do something.
Yes.
You do something.
3 years back,
sir, you more capable, Barkat, you more capable, you do it.
Yes, sir.
Very well said, sir. Very well said. You do something instead of criticizing.
You know very well.
Thank you.
Anything more, Andy?
Thank you.
Shall we close out? Anything to be asked, Bishnu Chandra?
No more question.
From any other body?
English and Indian law indemnity ఉంటుంది.
మీరు పేరు చెప్పండి, మీకు వినపట్లేదు. మీ పేరు చెప్పండి. And anybody want to ask? Now, shall we close it?
Yes, sir.
Okay. Now, I request SS Sukumar as a senior assistant public prosecutor to convey vote of thanks to our keynote speaker. Bishnu, tell.
Yes. Sir, before closing, I would like to say something. I would like to address the speakers, the listeners, that this is a very good forum created by the Bhatti Director Prosecution Andhra Pradesh, and this YouTube channel, we should all should promote this YouTube channel, and you should like the channel, share it, and subscribe the channel, and it should spread in the entire country and entire world, so that our message could be given to every prosecutor. So like, share, and subscribe. Like करें, share करें, and subscribe करें.
That's our program. SARS stating that our program is living in YouTube, and anybody can watch it, and everybody has to share it. And it is useful. It's an academic classes. Anybody can watch it. That's why we are giving live to the YouTube these programs. Okay. Now I request the Sukumar, Senior Assistant Public Prosecutor, Guntur, to convey closing remarks to our keynote speaker and chief guest today.
Thank you, sir. Good afternoon to all.
Convertla, Sukumar, no convertla. First open your camera. Right.
Sir, my camera is on, sir, I think.
Okay, now.
Sir, thank you, sir. Good afternoon to all officers. It's a great honor and privilege to address the seminar. I am SSS Sukumar, Senior Assistant Public Prosecutor, Guntur. My heartfelt thanks to our Honorable Director of Prosecutions, AP, Sri Baira Rangpotisrao, sir, for organizing this online seminar on the topic Strategic Approach to Witness Examination and Cross-Examination, a Prosecutor's Guide to Effective Advocacy. As our chief guest observed that our honorable director is a pioneer of this online prosecuting academy to improve the standards of prosecuting officers and is striving hard to attain better conviction rate through fair play. His coordination, encouragement, guidance clearly drive us to achieve targeted goals of the government in our directorate. I would like to thank our today's chief guest and keynote speaker, Sri Tapur Bishan Chandji, District Attorney, Himachal Pradesh, who provides us valuable insights into effective advocacy, witness examination, cross-examination, and digital crime. I thank, I, I thank on behalf of Directorate of Prosecutions of AP for his valuable guidance, contribution, and encouragement. Thank you, sir, for your suggestions, strategies that are crucial for successful prosecution. Art of cross-examination aims to discredit the accuracy, credibility, and value of the evidence so stated. Thank you, sir, for your suggestions, which are helpful to us to inspire and elevate our fraternity. Thanks for sharing crucial points on evidence and courtroom strategies and witness handling. Also, I thank our honorable joint directors, deputy director of prosecutions, and prosecuting officers, other staff members, and police officials who are taking part in this program. I am sure that each one of you has enjoyed a lot as an active participant in this today's seminar. Thank you very much. Have a nice day.
Thank you very much. Thank you very much, Bisham Chandra garu. Thank you very much. We'll meet again. Thank you,
Thank you, sir.
Sukumar.
Namaste, sir.
Namaste.
Namaste, sir.
Thank you, sir. Thank you.
Thank
Come
you.
to
Sir,
Himachal.
I would
Thank you
like
very
to
much. Namaste, sir.
take leave from
నేను ఏం
Namaste, sir.
చెప్తున్నానంటే ఆల్ ది ప్రాసిక్యూటర్స్ మనకి తెలిసిన ఎవరైనా గుడ్ స్పీకర్స్ ఉంటే మాకు ఇంటిమేట్ చేస్తే కాస్త నాలెడ్జ్ షేర్ చేస్తారు. మేము ఒక్కళ్ళమే ఎతకటం అంటే కష్టం. కాబట్టి మీకు తెలిసిన వాళ్ళు ఉంటారు ఎక్స్పర్ట్లు. కొంచెం ప్లీజ్ సెండ్ నేమ్ టు అస్, విల్ కాంటాక్ట్ దెమ్, అండ్ ఇఫ్ యూ హావ్ గాట్ ఎక్విటైజ్ విత్ దెమ్, ప్లీజ్ ఇంటిమేట్ దెమ్ అండ్ ఇంటిమేట్ టు అస్, విల్ కాంటాక్ట్ దెమ్. ఓకే, ఇట్స్ ఓన్లీ బై షేరింగ్ ఆఫ్. థ్యాంక్ యూ,
Thank you, sir.
బిష్మల్జీ. బై.
Thank you, sir.
Thank you,
Namaste.
sir.
Thank you,
Namaste,
sir.
sir.